हेलो एवरीवन, आई वेलकम यू ऑल टू प्लूटस आईएएस। चलिए स्टार्ट करते हैं हमारे लेक्चर सीरीज का एक नेक्स्ट लेक्चर जो कि होने वाला है एक प्रीवियस ईयर पेपर डिस्कशन। तो मैंने क्या किया है इस लेक्चर सीरीज में, व्हाट आई हैव डन इज आई हैव टेकन अ क्वेश्चन दैट वाज आस्क्ड बाय यूपीएससी इन द लॉ ऑप्शनल पेपर, ओके, एंड बाय द हेल्प ऑफ दैट क्वेश्चन आई विल एक्सप्लेन यू द एंटायर टॉपिक. So in this way, we will also get to know about a question, previous year question that will help in our preparation also, and we will be clear with a particular topic also. Okay. So let us start this topic, that is outraging a woman's modesty or sexual harassment. Okay. So what's the difference between outraging the modesty of a woman and rape? So we are going to discuss those topics in this lecture. Okay. So let us start. So the question that was asked in UPSC Law Optional paper. So the question was in 2017, and let us first understand the exact wordings of the question. Okay. So the question was basically discuss the different forms to outrage the modesty of a woman. तो जो अलग अलग तरीके, what are those ways in which the modesty of a woman can be basically harmed, okay, so which have been made punishable in the IPC. So obviously बात है कि now it is not IPC, it is भारतीय न्याय संहिता, but basically the question was in 2017 only, so that is why IPC is mentioned. Okay, so it is asking that in what forms or in what ways the modesty of a woman can be harmed by anyone, and those things which are basically punishable by the IPC through the Criminal Law Amendment Act 2013. Okay, what changes happened during that time? So basically this was the question, and we got to know about the question, but the thing that we are going to deal in this basically lecture is the topic. Okay, and the topic is the outraging the modesty of a woman. So let us understand this topic properly. So basically modesty means, so what is exactly the meaning of modesty? See, what happens is कि हम जनरल टर्म्स में अगर मॉडेस्टी की बात करें कि जनरली मॉडेस्टी क्या होता है, तो जनरल टर्म्स में मॉडेस्टी इज समथिंग डिफरेंट देन लीगल मॉडेस्टी. ओके, इन जनरल टर्म्स हम मॉडेस्टी में बात करते हैं कि अबाउट द क्लोथिंग, अबाउट द बिहेवियर, अबाउट द रिजर्व्ड पर्सनालिटी ऑफ अ वुमेन, है ना, कि एक मॉडेस्टी अगर वुमेन के पास में है तो उसकी बिहेवियर, उसकी क्लोथिंग. बट यहाँ लीगल टर्म्स में the word modesty is not about the clothing appearance of a woman, but it is in the legal terms rather about the dignity of a woman. A woman, by the virtue of being a woman, has a dignity. Okay, I understand that everyone has dignity, but because there are biological differences between the other sex and women, so other sex, that means men or transgender or something like that, so between them and a women there are biological differences, and because of those biological differences जो women के पास में एक dignity होती है, that dignity is said to be the modesty of that woman. Okay, so in the legal terms modesty is this. Okay, so it doesn't talks about the physical appearance of a woman, irrespective of the color, appearance, the status of the women. Every woman, by the virtue of just being a woman, carries dignity. Okay, that's a very big difference. Okay, so it means the inherent dignity. Is this dignity being given by some other authority or someone other than the women? No, it is, it it is basically there with the women by the virtue of being a woman. It is inherent. Okay, for example, this plastic marker, or I would say a pen, it has some inherent value, it has some intrinsic value. Just like this, the women, by the virtue of being a woman, carries some inherent dignity, inherent value, I would say. Okay, and sexual privacy of a woman. Okay, so modesty here means dignity of a woman and the sexual privacy. In the sexual terms, what privacy a woman wants to maintain, that comes under the definition of dignity. Okay, so violation of such modesty, so violation of these two things amounts to an offense which is punishable by the law and accompanied by the requisite intent and knowledge. Okay, so these two are basically the presumptions that are very common in the common law principles. Okay, and this offense is also a part of the common law jurisprudence only. So in that case, so these two requirements are there for imposing a criminal liability on the accused person. Okay, so let us understand. So in ordinary language, so dignity means the shyness of a woman, the decency that a woman carries, and the reserved behavior that a woman want to basically profess in public or the private arenas. So that is categorized as modesty. But in the legal term, law does not depend on the personality or the personal habits or clothings of a woman. Law does not discriminate between two women. Law just says whether it is a 7 month, 1 month old baby or a 17-year-old girl or 27, 37, 87, whatever the case be, age, other characteristic doesn't differentiate between women. By the inherent property of being a woman carries modesty, and that is basically described by the law. Okay, in law, modesty refers to a woman's dignity and the bodily integrity, not her character or conduct. तो बोलते हैं ना कि कैरेक्टर पे डिपेंड नहीं करता है कि एक वुमेन क्या वुमेन होंगी, कैसी वुमेन होंगी, नहीं, कैरेक्टर डज नॉट डिफाइंस, इज बेसिकली नॉट अ क्राइटेरिया टू डिफाइन अ वुमेन. ओके, it's a dignity that is the basic criteria to define a woman. So now this is basically the section 74 of BNS. So what does section 74 of BNS states? Say it is assault or use of criminal force to a woman with the intent to outrage her modesty. See, these are the two foundation of the criminal law. So those two foundation of criminal law are whether it's an assault or a use of a criminal force. Just by pushing someone doesn't amounts to criminal force. The intent should also be there. Okay, so these two things, assault or criminal force, if is there, and the intention of doing that is basically to outrage the modesty of a woman, then it amounts to the criminal liabilities as per the Bharatiya Nyaya Sanhita. So in section 74 of BNS, it is stated that assault or use of a criminal force to any women, okay, intending, so the intention here is to outrage or knowingly, and knowledge should also be there. We will discuss with the case laws what does knowledge here in this case stands for. So outrage or knowing it to be likely that we will thereby outrage her modesty. So the knowledge and the intention both is there that this particular act done by the accused will outrage the modesty of the women. So shall be punished with imprisonment of either description of a term which shall not be less than 1 year. And the criminal liability that will be imposed in that case will be the sentence of a term which shall not be less than, it should be only more than 1 year only, but which may extend to 5 years. So 1 to 5 year imprisonment can be there, shall also be liable to pay fine. Okay, so this is basically the bare act definition. Now understanding this statutory framework, so earlier in the IPC this offense was categorized or described under section 354, but now in section 74 this basically the injury to the modesty of a woman is given. Okay, so what is the legal definition given here? So it is assault or the use of a criminal force to any woman, and the intention should be to outrage or knowing that this particular act will harm the modesty of a woman. Okay, so what is the punishment? I told you it is 1 to 5 years or maybe fine. Okay, so plus fine. Object is to protect the women against indecent behavior. Okay, so protect a women from all such behavior that may outrage the modesty of a woman. Okay, to public morality and feminine dignity. So such an act that outrages the modesty of a woman is not just committed against that woman. It disturbs the public law and it is also against the public morality or the common conscience held by the society in general. Okay, and it also harms the feminine dignity. Okay, so आगे बढ़ते हैं. Next is what is the judicial interpretation of modesty? See, what has happened is Parliament has left it blank and has never or not basically, even in IPC it wasn't defined, and now in BNS also the meaning of the term modesty isn't defined. It has been left to the judiciary to interpret the particular meaning of the word modesty. Okay, so since modesty is not defined in the code, the judiciary has evolved its meaning. Okay, so for example, in the state of Punjab versus Major Singh in 1967, what the judiciary has stated, it has stated that the modesty is somewhat inherent virtue of a woman. Modesty is a virtue. It is a characteristic that is inherent to a female by virtue of her sex. By just being a biological woman, the inherent dignity that a woman holds, the inherent virtue that a woman holds is called as modesty. Okay, so its universality. So in by the various judgments of Supreme Court, it is also stated that it is this modesty is basically attached to all the females. Okay, whether it be young, old, intelligent, or basically impeccable, imbecile, or basically awake, or even under anesthesia, whatever the state of consciousness be, whatever the physical state be of the women is a woman, and modesty is basically attached to that particular women, whatever the case be. Okay, now what's the test? Whether the act is such that it shocked the sense of decency of a woman. So what will be the criteria to measure whether the outrage of modesty has happened or not? So the test will be whether this act has shocked the sense of decency, whether the act was decent or not. If it was decent enough in the eyes of general society, in the eyes of basically the conscious people of the society, if it was decent, then it won't be the outrage of modesty. But if it shocks the decency of the people in general, then that particular act will be categorized as an outrage of modesty. Okay, so triviality, what does triviality states? So basically in the Rupan Deol Bajaj versus KPS Gill case in 1996, it was stated that such a case which outrages the modesty of a woman will never be considered as a trivial matter. Okay, so there is a legal maxim also, de minimis. So this basically maxim says that those cases which are very minimal in nature, which are very trivial in nature, has not to be taken care much of. Okay, but in this case, the modesty can never be a trivial matter. It can never be a very small matter. It will have to be taken care of by the law and by the code in a very serious way. Okay, because this isn't a trivial matter. Okay, so what are now the essential ingredients for the conviction of an accused who is charged of committing the outrage of modesty? So the victim is a woman. Okay, now here in this case, applying section 74 of BNS, the person who is basically the victim shall be a woman. And what is a woman? What's the definition of women? Definition of women was earlier given by section 10 of IPC, but now is basically defined under section 2 of BNS. Okay, a female of any age, whether it be a 7-year-old girl or whether it be 17, just I told you, whether 57 or 87. Okay, so actus reus should be there. Now what's actus reus? The physical manifestation of the intention. Okay, so the physical appearance of the act that is now categorized to be as a crime. So that actus reus, in what form the actus reus should be there? So that's an assault. If an assault under section 130 of BNS is committed, okay, अगर या तो असॉल्ट हुआ है और या फिर एक क्रिमिनल फोर्स अंडर वन सेक्शन 129 ऑफ बीएनएस यूज किया गया है, अगर ये दोनों एक्टस रियस में से कोई भी एक एक्टस रियस हुआ है, देन तो पहली बात तो अगर वो एक विमेन है और उन विमेन के प्रति इन दोनों चीजों असॉल्ट या फिर हम कह सकते हैं कि क्रिमिनल फोर्स का इस्तेमाल किया गया है, एंड विथ अ थर्ड एलिमेंट दैट इज मेंस रिया वाज आल्सो देयर. ओके, मेंस रिया मतलब एक ऐसी स्पेसिफिक इंटेंशन रही होगी इस एक्टस रियस को करने की, जिससे उनको उनकी इंटेंशन या उनको पता था कि इससे उस विमेन की मॉडेस्टी हार्म होगी, इससे उन विमेन की मॉडेस्टी आउटरेज होगी. तो अब दोबारा इसको समझते हैं कि वो एक विक्टिम एक महिला रही हो. द विक्टिम शुड हैव बीन अ वुमन एज पर सेक्शन 2 ऑफ द बीएनएस. Now the actus reus has been committed, the physical manifestation of the crime has been committed, which is in form of assault or the use of criminal force, and intention or knowledge was there. So what's the difference between intention and knowledge? Intention is the basically the guilty mind that just precedes the crime. Okay, that just precedes the actus reus. And what is knowledge? That he knew the consequences of the act. He knew that by doing this act, the consequence will be that the dignity of the women will be harmed. In that case, if these three elements are fulfilled, then it will be said that the modesty of the women is outraged. Okay, now case reference is Shikara versus State of Karnataka 2009 case said that mere knowledge of likelihood is sufficient. Deliberate intention is not mandatory. Even if the person's intention wasn't to harm the dignity of a woman, it was stated in this case. okay, that even if the intention wasn't there, but the person knew this thing, that by committing such particular act, by committing such particular assault, the dignity of the women will be harmed, the modesty of the women will be outraged, then it will be said that yes, under section 74 of BNS, criminal liability will be imposed on that accused. Okay. Now next is pulling a woman's hand. For example, let us understand by these two illustrations. First is this, second is this. So for example, pulling a woman's hand, a person is pulling the hand of a female by criminal force. Okay, that pulling of hand was severe. Okay, that has basically given a hurt to the women. Okay, so by using a criminal force, if intention is to insult the dignity, and also, so this was the actus reus, and now this is the intention was to modest the dignity, or basically to insult the dignity of a woman. So yes, it will be stated that modesty of the women is basically harmed. Okay. Now raising hand to touch inappropriately. If a person is just raising the hand, for example, a woman is standing in front of that person and the person has just raised the hand, he haven't touched that woman. So just by raising the hand inappropriately will be categorized not as a criminal force but as an assault. And this assault was not in form of a physical touch नहीं हुआ है, लेकिन फिर भी this will be an assault and the intention of harming the dignity of the women was there, then it will be the outraging of the modesty. मतलब even if अगर आपने टच कर दिया है women को, ठीक है, और इवन टच नहीं भी हुआ है बट इंटेंशन वाज देयर कि मुझे इनको इनकी डिग्निटी को हार्म करना है किसी भी तरीके से, it will be categorized as a outrage of modesty. Okay. Next is intent versus preparatory act. So the court distinguished between the culpable intention and natural behavior. So the court has deliberately categorized these two things कि एक तो होता है कुछ natural behavior of the people. लोगों की कई बार होती है कि नजर कहीं रुक जाती है देखते देखते, ठीक है, that is not stalking, ठीक है, वो स्टॉक नहीं कर रहे हैं बट उनकी नजर रुक गई है, वो तो लोगों का नेचुरल बिहेवियर है. बट इन दिस केस एक होता है कल्पेबल इंटेंशन कि उनका सच में इंटेंशन था उस एक्ट को करने का. इसमें डिस्टिंग्विश किया गया है. जैसे रामदास वर्सेस स्टेट ऑफ वेस्ट बंगाल केस 1954 में सुप्रीम कोर्ट ने क्या कहा था कि अगर कोई इंसान लस्टफुल आंखों से किसी विमेन को देख रहा है और या फिर उन्होंने अपना ट्राउजर एक ट्रेन में उतार दिया कंफर्टेबल होने के लिए, सामने विमेन थी, ठीक है, और उन्होंने जस्ट वो ट्रेन में बैठे और उन्होंने अपना ट्राउजर उतार दिया और ये कह के कि भाई मेरे को कंफर्टेबल होना है यहाँ पर विदाउट फर्दर एक्शन, उसके बाद बेशक उन्होंने कुछ नहीं किया, उसके बाद आगे वो नहीं कुछ उन्होंने किया कि कुछ उसको टच किया हो विमेन को कुछ भी किया हो, दैट वाजंट देयर, डज नॉट सैटिस्फाई द बर्डन ऑफ प्रूफ फॉर इंटेंट अंडर सेक्शन 74. तो केवल अगर मान के चलो उनका इंटेंशन नहीं था, उन्होंने आगे बढ़े नहीं, वो उन्होंने जस्ट अपना जो है वो ट्राउजर उतारा कंफर्टेबल होने के लिए, ठीक है, और बेसिकली या फिर एक लस्टफुल आंखों से वो देख रहे हैं बस, दैट जस्ट बाय सीइंग दैट विल नॉट प्रूव कि उनका इंटेंशन ये रहा होगा कुछ करने का. ना उन्होंने एक्टर्स रियस किया, ना ही जो है उन्होंने कोई मेंस रिया था उनका. तो इन दोनों केसेस में सुप्रीम कोर्ट ने कहा विल नॉट अमाउंट टू द आउटरेज ऑफ द मॉडेस्टी. ओके, सो ये आउटरेज नहीं होगा. अब देखते हैं फिर आउटरेज कैसे होगा. एसपी मलिक वर्सेस स्टेट ऑफ ओडिशा केस 1982 में क्या कहा कि टचिंग अ बेली इन अ पब्लिक रिक्वायर्स प्रूफ ऑफ डेलिबरेट कल्पेबल इंटेंशन. अगर आप जो है मतलब एक किसी विमेन का एक क्राउड में या कहीं भी अगर आप उनका बेली टच कर दे रहे हो तो उसमें आप ये अगर प्रूफ कर देते हो कि कल्पेबल इंटेंशन भी था कि वो और अप्रोच करेंगे उस विमेन को, उनकी मॉडेस्टी हर्ट करने का उनका इंटेंशन था, then it will be categorized as an outrage of the modesty of a woman. ठीक है. Now outraging modesty versus attempt to rape. कई बार ये कंफ्यूजन रहता है कि outraging of modesty versus rape में क्या डिफरेंस है. ठीक है, कब ये कहा जाएगा कि अभी केवल मॉडेस्टी हर्ट हुई है विमेन की और कब ये कहा जाएगा कि रेप अटेम्प्ट किया गया है. ठीक है, तो देखते हैं हम कि आउटरेजिंग मॉडेस्टी और अटेम्प्ट टू रेप में क्या डिफरेंस है. तो देखो ऐसा होता है कि नेचर क्या है, मॉडेस्टी आउटरेज करने का नेचर है कि इट्स एन इनडिसेंट असॉल्ट फॉलिंग शॉर्ट ऑफ पेनिट्रेशन. सो पेनिट्रेशन इज द मेन पॉइंट ऑफ डिफरेंस. मतलब यहां पर जो है वो मॉडेस्टी हर्ट हुई है विमेन की लेकिन पेनिट्रेशन नहीं हुआ. इवन अ वेरी स्मॉल अमाउंट ऑफ पेनिट्रेशन, ठीक है, will also amount to rape but not outrage of modesty. outrage of modesty अगर हुई है तो उसमें penetration नहीं होगा. फॉर एग्जाम्पल जैसे किसी की लड़की के हाथ पकड़ लेना, ठीक है, उनकी साड़ी को खींचना, या फिर इवन स्क्वीजिंग ब्रेस्ट, people think that this is categorized as an attempt to rape, but this isn't categorized as an attempt to rape. हाँ, अगर इसमें intention was to further move and to basically do the penetration, okay, against the will of the women, then it will be attempt to rape. बट अगर ये इतना ही एक्ट हुआ और आगे का इंटेंशन नहीं था, then it will be categorized as outraging modesty but not attempt to rape. Okay, key cases are these, ठीक है, जैसे रामेश्वर वर्सेस स्टेट ऑफ हरियाणा, जिसमें सलवार की स्ट्रिंग को ओपना बट फ्लीइंग विद व्हेन रेसिस्टेड, ठीक है, तो एक सलवार को खोला एक विमेन की, ठीक है, लेकिन जैसे ही विमेन ने थोड़ा सा रेसिस्ट किया, सो द पर्सन फ्लू अवे, ठीक है, तो उस केस में जो एलिगेशन होगा दैट विल बी आउटरेजिंग द मॉडेस्टी। पहले सेक्शन 354 था, यहाँ पे आईपीसी के हिसाब से लिखा हुआ है। अटेम्प्ट टू रेप कब होगा? जब डिटर्मिनेशन टू हैव इंटरकोर्स एट ऑल इवेंट्स, जब से एक इंसान ने कोई भी विमेन के प्रति जो है अपना बिहेवियर स्टार्ट किया बढ़ने का, तब से लेके अगर इवन पेनिट्रेशन नहीं भी हुआ, बट उस लास्ट मोमेंट तक भी अगर इंटेंशन था पेनिट्रेशन का, अगर इंटेंशन था कि पेनिट्रेशन विल हैपन, तो इन दैट केस, मतलब पेनिट्रेशन इन लीगल टर्म इंटरकोर्स एंड पेनिट्रेशन था, तो दैट विल बी अटेम्प्ट टू रेप। ओके, फॉर एग्जांपल अंडरगारमेंट्स को रिमूव करना, तो अंडरगारमेंट्स को रिमूव आप कर रहे हो बट आप ये कह रहे हो कि आपका इंटेंशन नहीं था रेप करने का, तो थोड़ा मुश्किल है, ठीक है। सो पिनिंग डाउन विद इंटेंट टू पेनिट्रेट, सो अ पर्सन इज बेसिकली गोइंग डाउन ऑन अ वुमन टू पेनिट्रेट, पेनिट्रेट नहीं भी हुआ, देन आल्सो इट विल बी अटेम्प्ट टू रेप, बट अगर पेनिट्रेशन का भावना नहीं थी, इंटेंशन नहीं था, तो आउटरेज ऑफ मॉडेस्टी। ओके, तो जैसे राजेश विश्वकर्मा वर्सेस स्टेट, तो इसमें रिमूव विक्टिम्स पैंटी एंड अटेम्प्टेड पेनिट्रेशन, दैट विल बी अटेम्प्ट टू रेप। ओके, और पेनिट्रेशन अगर हो गया तो रेप हुआ, बट यहां पर जैसे फॉर एग्जांपल जो अंडरगारमेंट है विमेन के, वो रिमूव कर रहे हैं, और रिमूव करने से आप यूं समझ लो कि इंटेंशन है, चाह रहे हैं कि पेनिट्रेट करना, तो देन दैट विल बी अटेम्प्ट टू rape. Okay, so this is the end of our lecture. We have differentiated between the outrage to modesty of a women, तो हमने, और basically attempt to rape, और इससे पहले हमने outrage of modesty के पूरे टॉपिक को पढ़ा। So the purpose of this lecture was to make clear one particular topic with the help of just looking at a previous year question. Okay, अगर आप चाहते हैं कि मैं इस क्वेश्चन का प्रॉपर आंसर में कैसे लिखना है, अगर एक फॉर्मेट डिस्कस करूं, so please comment so please drop a message in the comment section, ठीक है। You can also reach out in case of any query, any concern, any problem to the official helpline number of Plutus IAS mentioned below, okay, and also can mail us. So thank you so much for watching.